Good afternoon, good morning. I know we have members joining us from across the country. I'm Nalini Vedapalli, and I'm sitting here at the Law Society of Nunavut and with member Megan Ross, who's actually sitting in the boardroom. Really wonderful to welcome you all to this Nunavut Code of Conduct updates and reminders. Megan has a presentation that is shareable on her screen as well, but also it's accessible on the Law Society's website. If you go onto our homepage, there's a section called CLE events. And if you click on the November events, you'll be able to access it. So I just want to welcome everyone again. The event is being recorded and we'll be able to post it online and make it accessible to our members. I also wanted to acknowledge this is a new initiative from the Law Society in order to receive some professional support in terms of IT and also with content. So we're glad that LexisNexis is joining us today to help us with delivering the best PD event on the Code of Conduct. So thank you to LexisNexis for offering to support today's event. So Megan's going to talk about some of the general updates, which are mainly more like clarification, but also as an opportunity as reminders for members of the bar, and we do have students joining us as well. If at any time after the presentation, you may have difficulty finding some of the documents that Megan is referring to, just drop us a line and we're happy to provide you with a little bit more detail so you can find those documents on the website. So thank you everyone, and thank you to Megan Ross, who's joining us from Iqaluit, traveled from Winnipeg, specifically for this important update on the Code of Conduct and some reminders. Both Megan Ross and Sasha Paul, members of the Nunavut Bar, have played an important role to support the Law Society for these updates. The last time we had done a round of updates on the code dates back to 2016. So really delighted that we're able to do this towards the end of the year. So over to you, Megan, who's just sitting in the boardroom. And again, if anyone has any question after this event, feel free to reach out to us at the Law Society. Thanks, everyone.
Thank you, Nalini. It's really my pleasure to be here today. Always a pleasure to come to Nunavut. As Nalini mentioned, my name is Megan Ross. I'm based out of Winnipeg. I practice at a firm called Thompson Dorfman Sweatman. I was supposed to be giving this presentation with my colleague Sasha Paul, but unfortunately he is unable to make it today. So I'll be your sole presenter, and I'll jump right in. We've got a bit of a varied presentation today. We're going to talk about a couple of things: the purpose of the Code of Professional Conduct, civility and respectful communication, discrimination and harassment, and these are new proposed amendments to the Model Code. Notices to the profession from the Law Society of Nunavut, and then the 2022 amendments to the Code of Professional Conduct, and these were approved in June of this year. The amendments to the code, as Nalini was mentioning, mainly clarifying obligations, not necessarily changing expectations, but clarifying expectations. So we've created a number of slides that cover each of those points, but I won't be reviewing them in detail, but we've appended them for your reference, and we'll talk about them a little bit once we get to that point. So talking generally just a little bit about the purpose of the code. The legal profession is self-regulated on the understanding that the profession will regulate it in the public interest. And so the Law Society publishes this code to assist in this purpose. And the Nunavut Code is based on the Model Code of Conduct that is generated by the Federation of Law Societies of Canada. And the Law Society of Nunavut created a mandate to review the code with the objectives of maintaining uniformity, which was one of the primary goals for the Model Code, and of making it consistent with local law, practice, and a distinct court system here in Nunavut. And so the code itself just describes the minimum standard of professionalism that you're expected to meet. And lawyers are expected to exercise their judgment in applying these standards to their own situations, their own unique clients, their own unique area of practice. And a failure to meet any of these standards can result in the law society taking regulatory action against you. And some circumstances, I want to point out, may be outside the scope of the code as it's drafted. It's not an infinite document. And so if you've got something unique that comes up, we encourage you to call the law society, talk to a senior practitioner, or even the courts for guidance. So moving on to civility and respectful communication. Civility is one of the sort of core pieces of the code. So we just wanted to take this opportunity to give everybody a little bit of a reminder of what their obligations are. So there's two primary rules in the code that govern civility and respectful communication. A lawyer has to be courteous and civil and act in good faith with all persons with whom the lawyer has dealings in the course of their practice. And then a lawyer must not, in the course of professional practice, send correspondence or otherwise communicate to a client, another lawyer, or any other person in a manner that is abusive, offensive, or otherwise inconsistent with the proper tone of professional communication from a lawyer. And part of the reason that we're talking about this today is it's kind of timely. A national study was just released on the psychological health determinants of the legal professions in Canada. It's the first type of in-depth study of this kind. It was funded by the CBA and the Federation of Law Societies, and it's really just off the presses, and it considers a number of factors, but also the impact of civility on mental health for lawyers. It paints a bit of an alarming picture of the wellness of legal professionals. And one key factor impacting lawyers' mental health is incivility. And incivility in the workplace, they define it as kind of one of the milder but still serious forms of psychological abuse that people can experience. And because it shows a lack of consideration and respect for others. Really, and this is a line that Sasha repeats often, it's really about not being a jerk to the people you're working with. Okay. One of the leading cases with respect to civility is Groya and the Law Society of Upper Canada. I'm hoping that everybody can see the slide on Groya right now. If not, there's a little bit of a lag, and I'll try and just talk you through it. But the Groya is again one of the leading cases here. The issue in Groya was really whether a lawyer's behavior in the courtroom amounted to professional misconduct on the basis of incivility. At trial, Groya made allegations against the Ontario Securities Commission prosecutors, including prosecutorial misconduct, impropriety, that the OSC was using a conviction filter and was preventing his ability to secure a fair trial for his client. It took until the 57th day of trial before a judge directed Groya to stop repeating his misconduct allegation. And no complaint was actually ever filed. The Law Society of Upper Canada, now Law Society of Ontario, had heard about this independently and started their own investigation. The hearing panel and the appeal panel both found Mr. Groya guilty of professional misconduct, but the Supreme Court actually overturned this decision. And they really noted the tension between zealous advocacy and civility, because lawyers are expected to be zealous advocates for their clients. And the Supreme Court noted, trials are hard fought, they're not tea parties. Lawyers have to fearlessly raise every issue, advance every argument, ask every question, however distasteful, that is in their client's best interest, that's within the boundaries of the law. And this is especially so in the criminal context, because liberty is at stake and you've got a constitutional right to a full answer and defense. So the Supreme Court said that the line between incivility and zealous advocacy depends on, the very specific facts of each case. And in applying this context-specific test, attention should be given to factors such as what was said, the manner and frequency in which it was said, and how the parties reacted at the time. The court did note that this doesn't mean that lawyers have a license to say whatever they would like in the courtroom. There has to be some reasonable basis for it. But a legal error by a lawyer in making some type of argument shouldn't form the basis for misconduct finding in this context, because it risks creating unwarranted damage to a lawyer's reputation, first of all, for raising something. And second of all, because defense lawyers in particular serve a very integral role in the legal community in holding the justice system participants accountable by raising any reasonable allegations that may arise in any particular case. And so the majority held that Mr. Groya's actions were reasonable in this case. And the Supreme Court also took into account the trial judge didn't correct Mr. Groya's mistaken legal position at the time, which had to do with abuse process because the law was evolving. But it's clearly not a bright line test, right? Its flexibility is necessary. And this is really underscored by the fact that this was heard by a full panel of the Supreme Court. The 3 judges that dissented applied the exact same test, but came up with an entirely different result. So what kind of conduct does the court consider to be, or panels consider to be, uncivil? This is kind of a laundry list of items, but overly aggressive or demeaning language, sarcasm, baseless allegations of impropriety, misconduct, or which impugn the integrity of opposing counsel's integrity, disparaging personal attacks against witnesses, inappropriate vitriol, and name calling. And name calling in particular comes from most of those are listed out in Groya. Name calling comes from a decision of the Court of Appeal in my home province, Manitoba, where a lawyer was calling a judge names without any base at all in a trial. We'll actually hear another case, and this fellow's name is Mr. Highstead, and he actually is involved in another matter that we'll be talking about in a second. So I mentioned earlier the national study on psychological health determinants of legal professionals in Canada. So I won't repeat that, but the only other thing I wanted to say is there's going to be 2 more interesting pieces coming out of this soon. I think in the fall, there's going to be some recommendations provided to for people to consider on how to improve mental health within the legal profession. And then also there's going to be a part 2 where they look at the differences between the territories and the provinces, which I think will be very, very fascinating. This table here comes from the first phase of the report, and it just gives a little bit of a breakdown of the proportion of legal professionals exposed often or many times to incivility during their professional practice. And you can see that generally minority groups and more vulnerable groups are much more exposed to incivility. So I mentioned Mr. Highstead. Here's another recent decision with respect to him. And the Manitoba Court of Appeal really upheld a lot of the same principles from Groya, which I won't repeat here. But there was an interesting paragraph from the Court of Appeal that I think summarizes the duties and sort of the competing interests of lawyers when they're advocating for their client. And Justice Spivak had this to say: "The code affirms the duty of an advocate to resolutely and honorably advance the client's cause, the importance of which has been recognized as the cornerstone of our adversarial system. However, the duty of resolute advocacy has its limits. It does not permit an advocate to act with incivility. It must also be discharged honorably by treating the tribunal with candor, fairness, courtesy, and respect. Further, a lawyer must not knowingly misstate facts of the law, the contents of a document, or assert as true a fact when its truth cannot reasonably be supported by the evidence. The duty of resolute advocacy coexists with the lawyer's responsibilities to the court, to other lawyers, and to the administration of justice." And so that's all found at paragraph 42 of that decision. One other decision I'll mention very quickly in the incivility context. This is a case out of BC involving Mr. Dupé, which I'm sure a case out of Ontario, where I'm sure I am mispronouncing Mr. Dupé's name, but it has to do with Mr. Dupé making inappropriate comments to a self-represented litigants and having inappropriate courtroom behavior. And so there was some evidence of extenuating circumstances that influenced Mr. Dupé's behavior at the time, and which resulted in a reduced penalty. In the court, the Law Society will consider those type of extenuating circumstances. Okay, moving on to the provisions on discrimination and harassment. These are all proposed amendments to the Model Code of Professional Conduct. So they haven't been considered or adopted into the Model Code yet. The Federation of Law Societies actually has a standing committee on the Model Code, which considers trends in the legal community and takes feedback from stakeholders and recommends amendments to the Model Code, and they've drafted these proposed amendments. And this could pose ultimately changes to the Nunavut Code, and the Standing Committee at the Federation considers feedback from the Law Society. The Law Society of Nunavut has actually had the opportunity to provide some feedback on these proposed changes in 2020 and 2021 consultations. So ultimately, these provisions are something that we could see coming down the pipeline for the Nunavut Code. I just want to highlight some of these changes for you today. So Rule 6.3-1 reminds Council of the obligation not to discriminate. It's a lot more specific than the previous rule that you'll see there. And the proposed commentary is all new for this section. It addresses the special responsibility of legal professionals to respect the requirements of human rights laws. And the amended commentary also refers to the requirement to respect workplace health and safety laws, reflecting the fact that these laws contain duties relevant to the obligations not to discriminate or harass and create safe workspaces. And so moving on to commentary number 2, this really focuses on the fact that discrimination and harassment undermine confidence in our legal profession and system. And so professional environment is one that is respectful, accessible, and inclusive, and it reminds lawyers to be mindful of unconscious biases that they may hold. Commentary 3 draws on the Truth and Reconciliation Commission's calls to actions, as well as the Federation's commitments to reconciliation, by noting that legal professionals should be aware of the ongoing repercussions for Indigenous peoples of Canada, Canada's colonial legacy, and advising that they should take particular care to avoid engaging in, allowing, or being willfully blind to actions which constitute discrimination or any form of harassment against Indigenous peoples. This fourth paragraph of commentary requires lawyers to be aware that discrimination includes adverse effects on systemic discrimination and can result from organizational policies, practices, and cultures. And paragraph 5 actually includes a definition of discrimination, which is a bit different than the code as it exists now, which refers back to human rights legislation and the definitions therein. This paragraph 6 references workplace health and safety laws, which I had mentioned in the intro here. And commentary paragraph 7 really sets out a number of examples of behavior that constitutes discrimination. And obviously, it's not a finite list, but provides examples for council to consider. Oops. Sorry, everybody. I somehow jumped to the end. Okay. Commentary paragraph 8 notes that it's not discrimination to provide ameliorative programs. And lawyers are also reminded in paragraph 9 that provisions of this rule don't only apply to conduct related to your practice. It applies outside of that as well. Lawyers are expected to meet this standard. Well, the Standing Committee is also proposing to define key terms such as harassment. And so, again, we're moving away from referring to human rights legislation generally and the definitions therein to stating that a lawyer must not harass a colleague, employee, client, or any other person. And then harassment is defined in the commentary under. The first paragraph here defines harassment for the purposes of the Model Code, and it expresses the well-established principle of human rights law that intent isn't required to establish harassment. The commentary then sets out a number of examples of behavior that constitute harassment, which include things like verbal abuse, bullying, abuse of authority. And this code goes further to include a definition of bullying as a form of harassment. And it reminds lawyers that the provisions of this rule don't only apply to conduct related to or performed in the lawyer's office or in the legal practice. Again, you're expected to apply this to your life outside of legal practice. The proposed amendments with respect to sexual harassment are similar in nature to the amendments we've discussed. Again, we're now specifying that a lawyer must not sexually harass a colleague, employee, client, or any other person. And then again, the commentary is new. It defines sexual harassment. It acknowledges that it can be directed at someone based on their gender identity, or gender expression, and it provides a non-exhaustive list of examples of when it can occur. And so you'll find that on the next slide 27 and 28. And again, behavior that constitutes sexual harassment, such as displaying sexualized or other demeaning or derogatory images, communications with sexual overtones, sexual violence, unwanted conduct or attention. And again, this isn't an exhausted list. Lawyers have to avoid condoning or being willfully blind to conduct in their workplaces that they may see. So if you see something in your workplace, there's an obligation on you to do something about it or to speak to somebody. Lawyers are reminded that the provisions of this rule, again, don't only apply to their legal practice. There's also new sections on reprisals. And so previously, you can see a lawyer, it stated a lawyer must not engage in any form of harassment of any person. Now, this has become a lot more specific to say, or participate in reprisals against a colleague, employee, client, or other person, because that person has either inquired about their rights or the rights of others, made or contemplated making a complaint of discrimination or harassment or sexual harassment, witnessed discrimination, harassment, or sexual harassment, or assisted or contemplated assisting in any investigation or proceeding related to a complaint of discrimination, harassment, or sexual harassment. So the purpose is to allow the people to exercise their rights freely without fear of reprisal. Like, for example, there's a list of examples of such behavior, threatening to or actually imposing a financial penalty on someone because they've participated in a complaint. I'll highlight one case here. This is a case out of BC, a very recent case out of BC, Davison, that just shows how seriously law societies are taking discrimination and harassment. There was a lawyer from BC who engaged in, quite frankly, terrible behavior, both sexual harassment and discrimination, and I won't get into the details of his behavior here. But what's really important is that The panel affirmed that a complainant doesn't need to make protest or complain right away to the Law Society. That will not be held against anyone making a complaint. And the panel took the allegations themselves very seriously after investigating. And Mr. Davison received a 4.5-month suspension and also serious conditions on his ability to practice thereafter. Now I want to move on to talk a little bit about some notices to the profession. Notices to the profession are issued by the Law Society, and they can be found on the Law Society of Nunavut's website. They're issued by the Law Society from time to time when there's something important that's come up that the Law Society would like to inform the legal community about. So I'm going to highlight some of the more recent and important notices that have come out. First is a notice to the profession with respect to communication with staff, social media posts, and professional responsibility. And again, we talked about this rule a little bit earlier, but it's a general reminder to treat Law Society staff with courtesy, and to really treat everybody with courtesy. But further, the Law Society also receives informal complaints regarding social media media comments made by members. And so ethical obligations on lawyers extend to both one's professional life and non-professional life, and this would include posts on social media. So lawyers who make posts and comments on social media should do so in a way that's consistent with the code. Next one talks about the unauthorized practice of law, which is always very topical in Nunavut. No person shall engage in the practice of law unless he or she is an active member of the society, and that's set out in the Legal Profession Act. And so in order to lawfully practice law in Nunavut, you either have to get your full call to the Nunavut Bar, or you need to obtain a restricted appearance certificate from the Law Society. The practice of law is defined extremely broadly. It can be, providing advice under legislation. It's extremely broad. So if you're a lawyer who is attempting to do any work under Nunavut statutes, but don't have your call, you're engaging in unauthorized practice. Nunavut's a signatory to the Territorial Mobility Agreement, but this is different than the Provincial Mobility Agreement that lawyers in the South are used to. Most lawyers in the South think nothing of, practicing your, 100 hours in other provinces. But you can't do that. You can't be a lawyer registered in Manitoba or Alberta and simply drop in to Nunavut to practice on a casual basis. So I just want to remind as well, this notice also notes that there's an obligation on lawyers to assist in preventing the unauthorized practice of law. So if you are practicing and you come across someone who doesn't have doesn't have their call to the Nunavut Bar, doesn't have an RAC, you must assist in preventing it and notify the Law Society. There's a couple of other notices that have to do with the practice of law with respect to being an investigator, arbitrator, or mediator, and I'll go through each of those very quickly. It speaks to, with respect to an investigator, this has to do with, writing reports for clients, doing investigations. And so if you're just doing a fact-finding investigation, if you're just drafting, doing interviews and drafting a report based on those interviews on very factual matters, that doesn't constitute practicing law. But if you're making recommendations based on the facts gathered and providing advice with respect to the legal implications of those recommendations, that does constitute practicing law. Once you're considering facts and applying them to the law, you're then practicing law in Nunavut. If you are engaging in this type of work and you don't have your call in Nunavut, retainer letters are important. You want to make sure that retainer letter sets out exactly what the scope of your work is. You need to carefully review and make sure that it accurately sets it out. But these retainer letters aren't foolproof. A retainer letter can set out that you are merely conducting a fact-finding investigation. But if what your actions are, the report that you issue shows differently, the retainer letter won't be enough to prevent regulatory action. So for acting as an arbitrator, acting as an arbitrator actually doesn't require you to be a lawyer. Arbitration in Nunavut is governed by the Arbitration Act. And so an arbitrator is not required to be a practicing lawyer when acting as an arbitrator under the statute. Provided that a person remains in their role as an arbitrator, the Law Society doesn't consider this to be the practice of law and wouldn't require the arbitrator to be a member of the Law Society. However, if you're representing a client in arbitration, obviously that's different and you would be practicing law. And the next one is mediation. And so mediation doesn't take place under any particular act, but a mediator doesn't need to be a practicing lawyer called in Nunavut. This doesn't constitute unauthorized practice. And so acting for a client, obviously that's different. It'd be the same as an arbitration. A person acting for a client in Nunavut must be a practicing lawyer called here. Okay. So now we've made it all the way down to the 2022 updates, and we've got a little bit of time left. So I'll take you through some of the more substantive points. So there's a number of substantive changes to the code. And so we've made these slides for your reference. And again, they're mainly clarifying points. They don't change the meanings of the sections. But I will point out there's two provisions here, slides 45 and 48, that have been approved in 2022, but haven't been adopted yet. And so slides 45 and 48 will be adopted in 2023. And so this is very much like what I was talking to you about earlier with respect to the amendments on discrimination and harassment. The model code itself was developed by the Federation of Law Societies, and then it serves as the template for the Nunavut Code. And these amendments in particular, apart from the two I've identified, were approved in June 2022 and form part of the current code. So a lawyer must perform all legal services undertaken on a client's behalf to the standard of a competent lawyer. And this in particular, this rule, the commentary has been adapted to reference the use of technology and really require lawyers to have a level of technological competence that is dependent on whether the use is necessary to the nature and area of lawyers' practice and responsibilities. Rule 3.1-2 provides that a lawyer must perform all legal services undertaken on behalf of a client's, undertaken on a client's behalf to the standard of a competent lawyer. And the change here is in the commentary in commentary paragraph 8. And it provides that a lawyer shall only express his or her legal opinion when it's genuinely held and is provided to the standard of a competent lawyer. So this is one of the upcoming amendments in 2023. And it provides that when it becomes apparent that a client has misunderstood or misconceived the position or what is really involved, the lawyer has to explain as well as advise so that the client is apprised of the true position and fairly advised about the real issues or questions involved. So really, you need to be making sure that your client is understanding what's happening. Rule 3.2-7 is in relation to dishonesty, fraud by the client or others. So you see the underlined portions here reflect the amendments. And so a lawyer must never knowingly assist or encourage dishonesty, fraud, crime, or illegal conduct. But paragraph B here is the change. Do or omit to do anything that the lawyer ought to know assists in or encourages dishonesty, fraud, crime, or illegal conduct by a client or others. Rule 3.2-8, again, is adding dishonesty into the rule. So this rule has to do with a lawyer who is employed or retained by an organization to act in a matter in which the lawyer knows the organization has acted, is acting, or intends to act dishonestly, fraudulently, criminally, or illegally, must do the following. And this really clarifies the chain of command in terms of what you're expected to do once you become aware. So if necessary, because the person from whom the lawyer takes instructions, the chief legal officer or the chief executive officer, refuses to cause the proposed conduct to be stopped, advise progressively the next highest persons or groups. And if the organization, despite the lawyer's advice, continues with or intends to pursue the proposed wrongful conduct, withdraw from acting in the matter in accordance with the rules in section 3.7. And this is the second amendment that's upcoming in 2023. And this has to do with including acts of omission into a conduct that is fraudulent, criminal, or illegal, not just positive acts. So the commentary for this rule, paragraph 5, requires a lawyer acting for an organization who learns that the organization has acted, is acting, or intends to act in a wrongful matter, may advise the CEO and must advise the chief legal officer of the misconduct. If the wrongful conduct isn't abandoned or stopped, the lawyer has to report the matter up the ladder. In some cases, if they continue on that path, in some cases, you may need to withdraw, and withdrawal means resigning from your position or relationship with the organization, and not simply withdrawing from acting in that particular matter. When you are withdrawing from representation, you must not do so except for good cause and on reasonable notice to the client. And this has been clarified somewhat with respect to when you're leaving a law firm, and mobility between firms is increased greatly, I find, in recent years. And so when you're leaving a law firm, the lawyer in the law firm must ensure that clients who have current matters for which the departing lawyer has conduct or substantial involvement are given reasonable notice that the lawyer is departing and are advised of their options for retaining counsel. And they need to take reasonable steps to obtain the instructions of each affected client as to who they will retain. And this doesn't apply to government lawyers, Crown, corporation lawyers, or any other public body, or a corporation or other organization for which the lawyer is acting in an in-house capacity. So both of these paragraphs here are new. When you are making legal services available to clients as a member of the private bar, there's an obligation on you to make legal services available to the public efficiently and conveniently, and subject to Rule 4.1-2, may offer legal services to a prospective client by any means. And so there's a new addition to paragraph 4 of the commentary, which speaks to the right to decline representation. And so a lawyer obviously has the right generally to decline a particular representation, but it's a right that has to be exercised prudently, particularly if the probable result would be to make it difficult for a person to obtain legal counsel or representation. And so generally, a lawyer should not exercise the right merely because a person seeking legal services or that person's cause is unpopular or notorious, or because powerful interests or allegations of misconduct are involved. And a lawyer that is declining to assist should assist that party in obtaining the services of another lawyer that is qualified in the required field. So Rule 5.1-2, there's been another addition here to the rule. A lawyer must not, when acting as an advocate, knowingly assist or permit a client to do anything that the lawyer considers to be dishonest or dishonorable. And with respect to incriminating physical evidence, there's a new piece of the commentary that speaks to a lawyer's advice. So a lawyer generally has no obligation to assist the authorities in gathering physical evidence of crime, but cannot act or advise anyone to hinder an investigation or prosecution. And the lawyer's advice to the client that the client has a right to refuse to divulge the location of physical evidence doesn't constitute hindering an investigation. So a lawyer has to be courteous and civil and act in good faith to the tribunal and all persons with whom the lawyer has dealings. And there's some new commentary that provides that legal contempt of court and the professional obligation outlined here are not identical, and a consistent pattern of rude, provocative, and disruptive conduct by a lawyer, even though unpunished as contempt, may constitute professional misconduct. These next two relate in particular to lawyers who practice real estate and who might use paralegals or other parties to submit documents for them. And so these rules have been updated to really reflect the reality that that's happening quite frequently. And so in real estate transactions using a system for electronic submission or registration of documents, a lawyer who approves the electronic registration of documents by non-lawyers is responsible for the content of any document that contains the electronic signature of the non-lawyer. When a non-lawyer is employed by a lawyer, has personalized encrypted electronic access to any system for the electronic submission or registration of documents, the lawyer has to ensure that the non-lawyer does not permit others to use such access or disclose their password, and that is consistent with the current wording of the code. But what has been added in commentary 2 is in a real estate practice, when it's permissible for a lawyer to delegate responsibilities to a non-lawyer who has such access, the lawyer should ensure that the non-lawyer maintains and understands the importance of maintaining the security of the system. And I know in my firm, the use of electronic submission and the use of paralegals in real estate practices has really exploded, but it's incumbent on the lawyer to make sure that that system is secure. Rule 7.1-4 has to do with encouraging clients to report dishonest conduct. A lawyer must encourage a client who has a claim or complaint against an apparently dishonest lawyer to report the facts to the Law Society as soon as reasonably practical. And it's really been changed just to add apparently dishonest versus dishonest. So inadvertent communications has changed a fair bit. And it's really to reflect the fact that there are a lot of, with the advent of emails, there's a lot of inadvertent communications now between parties, including documents that you perhaps didn't mean to include. And so if you're a lawyer that receives a document relating to the representation of the lawyer's client, and you know or reasonably should know that the document was inadvertently sent, you must promptly notify the sender. And so lawyers, the commentary here provides that lawyers sometimes receive documents that were mistakenly sent or produced by opposing parties or their lawyers. And if a lawyer knows or reasonably should know that such a document was sent inadvertently, then this rule requires the lawyer to notify the sender promptly in order to permit that person to take protective measures. Whether the lawyer is required to take additional steps, such as returning the original document, is a matter of law beyond the scope of the code. As is the question of whether the privileged status of a document has lost, that would be the matter of a dispute between the parties. Similarly, the rule does not address the legal duties of a lawyer who receives a document that the lawyer knows or reasonably should know may have been wrongfully obtained by the sending person. So for the purposes of this rule, a document includes an email or other electronic modes of transmission that can be read. And so some lawyers can choose to return a document unread. For example, when the lawyer learns before receiving the document that it was inadvertently sent to the wrong address. But unless a lawyer is required by law to do so, the decision to voluntarily return such a document is a matter of professional judgment ordinarily reserved to the lawyer. So you'll have to consider this in the context of your own file. So Rule 7.8-5 provides that if liability is clear and the insurer or other indemnity is prepared to pay its portion of the claim, a lawyer has a duty to pay the balance. So basically, it's to prevent any delay in paying out to an injured party. If the insurer is paying out their portion and there's a deductible portion that's required to be paid by the lawyer, it's incumbent on you to pay it right away. All right. That concludes the presentation, and now I think we've got 10-15 minutes for any questions.
While I'm just going to jump in, thank you, Megan. I just wanted to add a little bit of information since we have a lot of members joining us today. If ever you're looking for confidential general advice, the Law Society has established a collaboration with the Law Society of Alberta's Practice Advisors. So the information is on our website. I think under the tab for lawyers, you'll see there's 3 numbers for practice advisors. So you're welcome to reach out without hesitation when you have, conflict, how to deal with a colleague, whatnot. So please reach out. It's a free service. In addition, when Megan was referring to the notices to the profession, we welcome any questions from our members. If you're unsure if a certain part of your practice does constitute the practice of law, or you've got a colleague who is wondering if they need to apply for an RA, a restricted appearance certificate, or get called to the Nunavut bar and they're unsure if it's the practice of law, we're happy to take those questions, and it allows us to clarify through notices to the profession. They're posted online, but usually at our annual general meeting, it's an opportunity to compile those notices and remind our members that there's an opportunity to seek clarification on what constitutes the practice of law or not, like Megan spoke to a little bit earlier during her presentation. Thank you. I just wanted to add a bit of that information as well.
I see we've got one question from Kim Gilson that I'll just read out before I answer. So Kim's question is, where in-house counsel learns of corporate wrongdoing, the commentary appears to deal with ongoing wrongdoing, and what is the obligation to address any matter that was a one-time event? And so it's my understanding that it's your obligation as a lawyer to advise your client that it's wrong and have the action stopped. And if you've done that, then you've satisfied your obligations. It's where there's ongoing wrongdoing that either your client isn't responding or continues with the act or omission. Then your obligation to withdraw arises.
We'll give it a last round. If we have any questions, I welcome you to send your questions now.
Also, feel free to email Sasha or I after the presentation. You can find if you Google my name, you can find my email address. It's mcr@tdslaw.com. I'm happy to take any questions or speak to anybody after the presentation.
All right, so I will thank Megan for joining us in Iqaluit and for putting together the presentation. And again, if there's anything that you was unclear today, you want further clarity on either some of the provisions or areas that relate to your practice, or a colleague who's looking for clarity on what constitutes the practice of law or not, I think most of our members are in contact with the support@lawsociety.nu.ca account, and I don't hesitate to reach out. So thank you again, everyone, for joining us. As I mentioned, the recording will be made available, and I thank LexisNexis for offering the support for today's event. Nakome, have a good day, everyone. Thank you.